106.5 FM. WNOV, The Voice. The views and opinions expressed on this show do not reflect that of the staff and management of WNOV and W293 CX 106.5 FM Courier Communications, Milwaukee, but are the sole comments of the host and guest of this particular show.
Everyone, and welcome to Money Talks with Attorney Coral. I'm Attorney Coral Pleas, the host of the show, and you are listening to WNOV 860 AM 106.5 PM. This show is sponsored by Columbia Savings and Loan Association. Stop in and see us at Columbia Savings and Loan Association, 2020 West Fond du Lac Avenue in Milwaukee. Come on in and open a savings account or a certificate of deposit. Or if you are in the market for a home, give us a call and set up an appointment to come in and meet with someone on our loan team that can help you in that process. The phone number for the bank is 414-374-0486. That is 414-374-0486. So I'm glad to be back. I've been away for a couple of weeks, not vacationing, but working hard at the bank and making sure that we have our I's dotted and our T's crossed, and that we are positioning ourselves to always provide the best service to our customers. That's our goal. That's our aim. And sometimes when I'm not able to be here, it's because I'm pushing up my sleeves, helping to get things done there. But I am happy to be back and happy to talk to you today about a topic that involves estate planning. So estate planning is something that I talk about throughout the series of the Money Talks shows. We've spent a lot of time already talking about wills. We've talked a lot about power of attorneys because that's something that I think is very important, whether it's power of attorney for healthcare or the other durable power of attorney. We've talked at length about those things. We've touched a little bit on the topics of insurance and future shows. I plan to go into that a little bit more. But one thing that we haven't talked a great deal about has been trusts. So today, I want to just give a real basic overview with respect to trusts, in particular revocable trusts, which are typically the types that I deal with in my legal practice. So I want to talk about that a little bit today and get into some of the issues that can arise when you have a revocable trust. Today's show is going to be, as always, educational and it's informational. Excuse me. What I'm not doing is I'm not giving legal advice. That's not something that I can do over the radio. If in fact you have a legal question with some specificity that you would like for me to respond to, I would ask you to reach out to my law firm phone number and schedule an appointment. If you mention that you heard from me on WNOV radio, you will have a free consultation to talk to us about whatever the legal issue related to estate planning. So the phone number for the Pleas Law Firm is 414 247 9570. That is 414 247 9570. Mention that you heard from the law firm through Money Talks, and we'll have a free consultation for you relative to your estate planning issue. Okay, so without further ado, let's talk about trusts. So, what is a trust? A trust is, by definition, a legal instrument that is created by a lawyer. A trust is similar, like, think of it this way, like, this is what allowed me to have a better understanding and really just get it in my head what a trust is. A trust resembles a corporation, right? In that it is a separate entity of its own that can own or buy or sell or hold or manage property according to whatever specific instructions you set forth in the trust. So, a lot of people understand, let's say, for instance, if you start a business, a lot of people will create their own LLC, right? And I think that that's more a basic understanding that people have. People understand that an LLC is an entity that is separate from their individual selves, right? So you go through the process of creating an LLC and registering it with the state of Wisconsin. There's a whole legal process for that that a lot of people are familiar with. And you actually then have an entity other than you, right? You may be the sole member, the person who owns the LLC, but when you create an LLC, it is its own separate entity. So just like as individuals, we all have social security numbers. If you are an LLC, you have an EIN number or a tax identification number. Sometimes with respect to trusts, even trusts can have their own separate tax identification number. So think of a trust as kind of, I'm just making an analogy, right? I'm not saying a trust is an LLC, but by comparison, just for sake of understanding, a trust is an entity that is created by an attorney on behalf of a customer, so that the trust is something separate from you. It is an entity separate from who you are. Okay. Today in particular, I would like to talk about revocable trusts, which is also called sometimes a living trust or even a revocable living trust. And that is a legal document that allows you to control your assets while you're alive and to decide who receives them after you die. What's important to note about a revocable living trust, and I'll say this more than once, I'm sure, is that you can change or revoke the trust at any time. Okay. Now, just very basically, there are typically three parties who are involved in a trust. The first is the grantor. So that's you, if you're the person who's creating the trust, or who's paying the lawyer to draft the trust, or the person who is depositing the funds or the assets into the trust. That's the grantor, right? The person who's creating it. The trustee can be the same as the grantor. It is not always the case, but it often is. But a trustee is the person or entity, right, who is appointed to oversee the management of the assets in the trust and to follow any instructions that the grantor has written in the trust. And then third is the beneficiary. Now, again, I'm speaking about this in very simple terms. Of course, there can be multiple beneficiaries. Let's say if there's a father and he has three children, the father may create a trust. He may be the grantor. He may make himself the trustee so he can make the decisions and oversee things during his lifetime. And he may name each of his 3 children as beneficiaries under the trust. So even though I refer to it as a beneficiary, understand that a beneficiary can be one person, it can be multiple people, it can be entities, but I don't want to get too far down the rabbit hole on all of that. I just want to speak generally. Okay. So, how does a revocable trust work? All right. So, you meet with your attorney. They draft this trust agreement for you, and you name a trustee who is going to manage whatever are the assets that you put into this trust. The trustee can be you, as I mentioned. It could be your spouse, your friend, a relative, or any qualified person, or even a corporate entity. That's not typically what I see in my day-to-day practice. Often what happens if it's a couple that's creating a trust, a married couple, let's say the husband may be the trustee, and then we'll perhaps name the wife as the alternate trustee. So let's say if the husband were to pass away, and then the wife will be named as a trustee, or even if the husband is yet alive and for whatever reason he might be incapacitated and not able to be in control of the trust, you can list a spouse or some other friend or relative as an alternative trustee. So the first thing you do is you decide who's going to be in charge to direct this trust and how you would like for it to work. The next thing that you do is you meet with your attorney and you direct how the assets that you include in this trust should be distributed. So for the time being, while you are still alive, and I'll talk a little bit more about this in detail as I'm making a point of talking about revocable living trusts. Give me a minute and I'll get to why that's important. Um, but but in with more details in terms of pros and cons. But for right now, just understand that what's significant about a revocable living trust is that you can revoke it or amend the trust at any time during your lifetime, as opposed to irrevocable trusts, right? Which are a different type of trust, a different type of entity, and they serve different purposes that we won't get too far into today. But there are, for example, sometimes reasons that you would create a trust that you cannot revoke. And it has to do, let's say, for instance, with protecting assets such as a home. If you anticipate that you might need to go into a nursing home for nursing care, there's sometimes that might be a reason. I should phrase it that way, that might be a reason that a person may consider preparing an irrevocable trust versus a revocable trust, because you can secure and protect assets in a way through an irrevocable trust that a revocable trust does not grant that particular extent of protection. Okay. Um, so the grantor, the trustee, and the beneficiary, at least a primary beneficiary, can all be the same person. In some cases that happens. That's not always the case, but that's a possibility. So trusts are either revocable or irrevocable. Um, and the revocable ones allow the grantor to change the instructions in the trust and take assets out of the trust, or even terminate the trust if they choose to do so. So it's important to know that with a revocable trust, you still maintain the authority over your assets. If you're in a revocable trust, for instance, if you put your home, you can still sell your home. It's still your home, right? If you put your bank accounts, you connect them and add them to the trust, you can still handle and maneuver your own money. Those are some of the benefits of having revocable trusts. So let's talk about that in a little more detail, a little more specificity. So again, revocable trust can allow grantors to disperse assets in ways that would be difficult to do with other estate planning tools. Um, in a revocable trust, all assets that are deposited into the revocable trust are unconditionally exempt from the probate process, which can greatly simplify and accelerate the estate planning process. Um, all activities relating to trusts and their dispersion of assets to beneficiaries are strictly confidential. It's not published to the public, as is the case if you go to probate. Um, let's talk about this just a little bit more so in terms of bullet points. Um, what are some of the pros of creating a revocable trust? All right. I've said it a few times, but a revocable trust may be altered or revoked at any time by the grantor. So you still maintain your ability to control your assets, the flexibility of being in control still of your assets. Another benefit of a revocable trust is that, and this is a big one, assets are exempt from the probate process. And that can simplify your estate planning. So that's mostly when people come in and they would like to talk about having a revocable trust established, is because they don't want to go through probate, or, well, the person who's starting it won't be there, right? But by definition, if it goes through probate, it means someone has passed away. But you're simplifying things for your heirs, you're simplifying things for your family, you're simplifying things for your loved ones, that, after you are no longer with us, that you would like for them to be able to just transfer assets in a way that you would have wanted them to do without going through the probate process. So assets that are in a revocable trust are exempt from the probate process. Um, you can continue, this is another pro, you can continue to use the assets that are in the trust while you are alive. They're not held back from you in any way. And the activities relating to a trust and the dispersion of your assets is strictly confidential. Unlike probate, where everything becomes a matter of public record if it goes to the civil courts, and people can go online nowadays and look things up and pull records, and the privacy, um it's just not there. If you are in an open civil court, you can have privacy with how you choose to handle your affairs if they are secured in a revocable trust. So, what are some of the cons of being of creating a revocable trust? Well, if a grantor is sued, in other words, the person who created the trust assets can be used to satisfy a judgment, because these are assets that are accessible to you in your lifetime. So putting them in a revocable trust won't shield them if you get sued for some reason. Assets that are in a revocable trust may be subject to satisfying any judgment that might be taken against you. Another con of having a revocable trust is, once the owner dies, trust assets can be subject to estate taxes. So that's something else to consider. Um, and lastly, not that there aren't other cons, this is just some of the stream of consciousness I had when I was preparing this outline. Trusts that are complex or that deal with intangible assets may be more costly to set up, because you're looking at more attorney time to put those matters in play. So those are some of the cons, some of the pros and some of the cons that I've thought about. We'll talk a little bit more about it, but I would like to give the number here, 414 414-5250. That is 414-444-5250. Give us a call here at WNOV if you would like to add something to the discussion about revocable trust. Thank you. We've got to take a break and we'll be back in a few.
Lester Kern.
The passing of a loved one is emotional enough without adding the stress of funeral arrangements. By pre-planning, you receive the desires of your heart while taking away the burden from your family. It also saves you money, providing the dignity and respect your memory deserves. And there are times when life ends unexpectedly. Please know that the New Pitts Mortuary is here to lend a helping, caring hand anytime, day or night. We are the New Pitts Mortuary.
WNOV, The Voice.
Welcome back. Welcome back. This is Money Talks with Attorney Coral, sponsored by Columbia Savings and Loan Association, and you are listening to WNOV 860 AM 106.5 FM. I think I said PM before, and I I had to laugh. I have to laugh at myself sometimes. Gotta keep a sense of humor. So this morning, we're talking about revocable trusts, which, estate planning is not fun stuff, right? It's not fun to talk about these things, but the only thing worse than talking about these things is not talking about these things, because we have to all plan for the inevitable. And the more we plan in advance, the more we ease the burden on our loved ones, and so forth, when we're no longer here. So before I go into the next segment, it does look like we have a caller holding. So if the caller would like to go ahead, Jermaine. It looks like we've got somebody. Oh, okay. I guess they were waiting, so they hung up. Okay. Well, maybe they'll call back if they like to add to the discussion here. We're talking about trust, and a trust is a legal instrument created by a lawyer. A trust resembles a corporation in that it is a separate entity, and it can hold, manage property or any assets that you put into the trust. We are specifically today talking about revocable living trusts. And the significance of that is that a revocable trust is a document that allows you to continue to control your assets during your lifetime, but it also specifically will tell the trustee who's in charge what to do with your assets once you're no longer here. So that is what we are talking about today. Looks like we have someone who would like to join the discussion. Caller, please go ahead.
Hello. How you doing?
I'm doing well.
Quick
How
question.
are you?
Listening to you, I was fortunate to hear what you were talking about. All right, quick information.
Mm-hmm.
Had a family member pass. I'm the last of the family. I know that majority of the stuff was left to me because, well, anyway, all that done. I hear about you saying a trust. Okay, my nephew, whatever was that. So that's all done, but now the property. And is there a way I can find out what's going on? What's the legal way I can ask questions? I called the lawyer, conflict of conference, of whatever. I can't ask information because it's only for him. He's out of town. I can't contact him. I'm on standstill. What would it cost to talk to you, to answer questions that I need, because I don't know where to look it up and find it out myself? So I'd rather go eye to eye, ask the question, what would it cost me?
Sure. So right now, for sake of having a consultation, if you mention that you heard about me from WNOV radio, I'll give you the number to call my law firm, and we will provide you with a free consultation to at least
And your
discuss
law
the
firm
issues.
is?
The name of the law firm is the Pleas Law Firm. My name is Coral Pleas, and I am the owner.
Go ahead.
Pleas is spelled Pleas, and
EAS.
yep,
Okay, no Z. Okay,
no Z,
got it.
although it's pronounced that way. Jermaine and I were talking about the spelling and the pronunciation of my unusual last name before we came on the air today. So the phone number is 414-247-9570. That is 414-247-9570. You can give us a
9570.
yes,
Okay,
that's
I'm
right.
military. It's best to say double digits because it's easier to pronounce and easier to remember because you can put it to tunes.
Oh,
So
all
say
right.
6570, and older people will remember double digits more than they can remember individual.
Okay, well that's helpful to know. Maybe that'll help me because I had to write my own numbers down nowadays because I've
All
gotten
right.
so with that
Try them in
smartphone
double
that
digits like you had in combinations, because that's the way we were raised, and you'll find out you'll remember a lot more numbers.
yeah.
All
I
right. Have a
usually
nice day. I
okay.
will be calling you. You still didn't give me a round number about like what it's going to cost to talk to you. I've heard about the consultation, but
Mhm.
hey, man, I'm a talker and I want to get information. I'm gonna ask questions. So, what it going to cost to talk to you?
Well,
All right. Love
yeah,
you. Bye.
no, the okay, go ahead. He can go, but the consultation that I'm offering is a free 30-minute consultation. Let's put it that way. I'll put a limit on the time frame so that then you understand because obviously time is money in the field, so I can't talk all day. But we can do a 30-minute consultation free of charge. And if there's additional information that is still needed after that, if we have to go research, if we have to look into anything in order to get back to you, then we'll have to talk at that point about what the rates might look like. Okay. So I appreciate that call and hope to be able to speak to you. So now it looks like we do have another caller holding. So caller, please go ahead.
Yeah, I got a quick. Uh, just say, for example, my mother set up a trust for her properties. Could I put my property in her trust, or I have to set something separate up?
Okay, so I appreciate the call. So here's the situation that we have to do because I have to be very careful when I'm on the air to not give out legal advice or legal guidance
Mhm.
on things. But what I can do is give you the phone number so that we can speak privately to you off the record. That way we can gather enough details and specifics in order to be able to fully answer your question. Does that sound okay?
Yeah, that's fine.
Okay, so the phone number again for my law firm, which is the Pleas Law Firm, the number is 414-247-9570. That is 414-247-9570.
And you said it's the Players Law Firm.
That's right. So I tried to
Okay.
do the little trick that the other caller said with the 9570. So hopefully that'll help. 247-9570.
And it's PLEAS.
P like in please. LEAS.
Okay.
Okay. So yep.
Thank
So you can give a call and please mention that you heard from us or you heard about us on WNOV radio and then you'll have a free consultation. Okay.
Okay.
So
Thank
thank
you.
you. Thank you and look forward to hearing from you. Okay, so that's good. So this is an important topic, and like I was saying before, it's not a fun one. No one wants to think about their own demise, but it's a reality, right? The biggest reality of life is death. It comes to all of us. So it's better to prepare to leave your loved ones in the best situation that you're able to leave them in. So a revocable trust is the topic that we're on today. What I really want to talk about is the notion of funding a revocable trust. Okay. Because if a trust is fully funded, it's a great it's a great thing. It's a great tool to use. Um, After your death, it makes things easier for your loved ones to be able to disperse your assets as you wanted them to be dispersed. But if you don't fully fund a revocable trust, there can be some serious problems. And I'm going to put a pin in that comment for right now because I do have another caller holding and I would like for everyone to have the opportunity to either add their comments to the discussion or raise a question. If they're too specific, I might not be able to answer on the air, but we will offer a free consultation. But to the extent I'm able to answer on the air, I'll try to do so. So, caller, thank you so much for holding. Please go ahead with your comment or question.
Hello.
Yes, hi. Please
Hey,
go.
hey. Good morning. Good morning to you.
Good morning to you.
Yes, I was calling because I was listening to you talk about a trust, and I would like to create a trust for my niece because I own a home, and my question is, if you still owe the mortgage on the home, could that be put into a trust?
Um, yes, you can still put your home into a trust. And please, you can feel free to give a call to my office. We will offer you a free consultation to answer questions that you may have about that process and hopefully be able to assist you. We'd be happy to.
I appreciate that. I got your phone number, but I forgot your name.
Coral Pleas, Pleas. So
Cool.
Yep.
Okay.
So I own the law firm. So you call and you'll get one of my paralegals that will answer the call, and they will take some initial information from you. But I am the only attorney in the firm, so that they take the initial information, but the call will come to me for purposes of talking to you.
Okay, that sounds really good.
Okay.
Hey, is creating a trust, is that a very expensive thing to do?
Well, it depends on the trust, right?
Okay.
So I would say that with the ones that we do typically in terms of revocable trusts are depending upon how complicated they are, how many assets you need to move, how many beneficiaries you're going to have, what are the terms. Those are the sorts of things that can dictate the price range. But they're generally, I'm going to just give an estimate, between $1,500 to maybe $2,900 or $3,000. Most of what we do is accomplished within that range of funds.
Okay, that sounds reasonable.
Okay.
All right.
Okay.
Thank you so much. I will be calling you.
Okay. Thank you. We appreciate the call.
And is there a good time to call you, or anytime at your office?
Anytime is good, because my paralegals are very good and they keep that phone with them, and they're able to answer even when I'm on the air with WNOV.
That sounds really good.
So they can take the call. So thank you so much.
I appreciate it. Thank you so much. You have a great day.
Thank you. Bye-bye. You as well. Okay, so we were talking about funding revocable trusts, and what does it mean to fund a revocable trust? And I thought about that because I thought, people need to understand, just in the most basic language, what does it mean to actually fund a trust? So funding a trust is really retitling assets so that they belong to the trust, that they become a part of the trust. So let's say your name is, I don't know, John Smith, and your lawyer creates a revocable living trust in the name of John Smith. So John Smith Revocable Living Trust. I'm just making something up to illustrate the point, because there are actually some rules that govern what you can name a trust and how you do name a trust. But let's just say you can call it John Smith Revocable Trust. Well, then if you own a home and you want to put that home into the trust, the lawyer may create a deed that transfers the title or the ownership of that property from your name to the name of from John Smith to the name of John Smith Revocable Living Trust, right? So that now the property becomes a part of a trust. You're retitling that asset in order to include it in part of the trust. So when I speak of funding a trust, I'm talking about retitling your assets so that they become a part of the trust. So, and the reason that I say that this is something important, and I'm going to give some other examples. I have seen this, not with my practice, because we make a point of being more conscientious and really try to impress upon our customers the importance of funding the trust. Sometimes people will go, they will meet with an attorney, and the attorney drafts the trust, and the attorney may even draft the deeds and so forth that you may need to complete in order to transfer property in the trust. And they give the person this packet, and the person is so happy, I've got my trust, it's all set up. And they go home and they take this stack of papers and they stick them on the shelf and forget about them and just think, well, I did my trust, I checked that box, and now I don't have to worry about that. My estate's all taken care of. Well, hold on a second, because what if you also had some bank accounts or some investments or whatever the case may be, other assets that perhaps the attorney cannot go and transfer on your behalf. Um, and financial assets is really a good example of that. If you've got money in an account in a bank, the attorney doesn't have necessarily the authority to go to that bank and change the name on your account, but that is something that you can and should and must do if you want that account to be included as part of your trust. So, what I have seen in certain instances is people have some of their assets funded or retitled to the trust, and other assets that you may think are covered as part of the trust, but they're not unless you put them in there, unless you fund them or retitle them and make them a part of the revocable trust. Um, so let's say if your trust is fully funded and every asset that you have has been retitled. So now that it's a part of the trust, then you pass away, and then whomever is the successor trustee can look at that trust document. Now, in theory, this is the way it would go. They look at the trust document, they take it, okay, here's X, Y, and Z beneficiaries. Let me go and make sure they get the assets that are all identified in this trust, get everything transferred to the right people. You don't even have to make a stop at probate court because every asset that you had was fully funded or retitled into the trust. Then things go more smoothly, right? But sometimes that doesn't happen, and people will, I have to say more than sometimes. I've seen it too many times where that didn't happen for whatever reason, whatever the disconnect or miscommunication or misunderstanding, that all of the assets did not get retitled and put into the trust. And then you have a problem, because to the extent that trust is not fully funded, or an asset of that trust is not fully funded or retitled, then you still end up having to go through the probate process. And that was what the trust was set up to attempt to avoid in the first place. So it's frustrating at that point, because the reason that you did the trust in the first place can be negated by the fact that you didn't fully fund it on the back end. Okay. So, what are some of the reasons why trusts don't get funded? What I've seen from time to time, this hasn't come up too often, but what I have seen is circumstances where a guarantor or grantor doesn't tell the attorney about all of the real estate that they have. Um, Maybe you tell the attorney about the home that you live in. Maybe you remember to tell them about a vacation home, but you forgot to tell them about that little tract of land that you own down in Arkansas somewhere. Because I hear that a lot. People forget about some of these things that you don't, think about on a daily basis. So then if something happens, you pass on, then your relatives say, okay, yeah, well, here's the home and here's the vacation home, but there's that little tract of land that I own because it was given to me by my great grandmother or whomever. But now you got to go to probate in order to get that tract of land either into the trust or whatever the determination of the probate court. So it kind of negates the purpose of having the trust if you don't have everything in there, because now after you're gone, the loved ones have to work, they got to spend money, they got to hire lawyers, they got to go to court, they got to work through the process. Whereas if you had just remembered to include that tract of land in the trust, it could have been a smooth transfer. Okay. One other example or other reason that trusts don't get funded. Let's say you open an investment account after you had already formed your trust, and then you forgot to go back and say, oh, I still need to put this new account in the name of the trust. Then you pass away, and what happens is that investment account gets frozen because you're gone, and it was in your name, not the name of the trust. If it's in the name of the trust, the trustee can come with his paperwork or her paperwork, and they can tell the holders of the investment account, okay, here's the trust and here's how that money should transact. Nope, not if it's in your individual name rather than in the name of your trust. So that's another thing that ends up getting bounced back to probate court, and your loved ones have to go through the process that you set up this trust to try to avoid. Um, Another way that I've seen this happen where trusts don't get fully funded. Let's say a person has their trust set up, they've got their home in the trust. Then, because you can still transact, right? Because it's still your home, you still can do whatever you want to do with it. You sold that home and then bought a new home and neglected to put the new home in the trust. So now again, you're back to square one if anything happens. Another way that I've seen this happen is when people think that they've designated beneficiaries on all their investment accounts. Um, so let's say you've got your traditional IRA, you've got your Roth IRA, you've got all of that covered, but you've got an individual investment account and you don't have a beneficiary designated, and somehow it's overlooked. Those are problematic too, because if you pass away, accounts get frozen and then they end up having to go through the probate process if there's not a specific documentation set aside to direct how those things should be handled. Um, while we're on investment accounts, let's say you've got investment accounts that are properly identified in your trust with the proper beneficiaries listed. But what if, and this happens, people may retire from a job and be gifted shares of stock on the side, um, that you forget to take and sweep that into your trust. You keep them in your own individual name. And so, again, if something happens to you, they end up getting frozen and your family has to go through the probate process. So, I've got a few more examples to discuss when we come back from the break. This is Money Talks with Attorney Coral, um, talking about revocable living trusts. We'll be back after the break. the day. It looks like the queue is there. Okay, so I had more to say, but I always over prepare. We'll talk about this again because it's an interesting topic. Thank you to everyone who called in today. Looking forward to seeing you next week. More Money Talks with Attorney Coral on WNOV 860 AM 106.5 FM. Have a great week.